I didn't like the looks of it. It's all very vague, and it begs the question to me, what would his report to DCF have sounded like? Well, so I've got this wife, and we got marital problems, and we fight a lot, and half the time she tells me I'm jealous. And she tells me about these men who admire her, these professional football players who show up at practice. And she tells me about that. Oh, did I mention to you she had an affair with her ex-boyfriend last year? And the other reason I think she might be targeting kids is because when she goes jogging in the summer, she tells me about the people who honk at her. Oh, well, are those children who are honking at her? No, I don't know. She doesn't know who's honking at her. I mean, this is the report. Or even more specific to that football game, she's holding our daughter as a prop. What does that mean in this context? Holding her daughter as a prop, does that make it more or less likely that she's a predator of children? And so all of these things, the appellant is making it sound as if they jump out at you as being so indicative of sexually deviant behavior. And to me, as I think I said in my brief, when you hear hoofbeats, you think horses, not zebras. There are a lot of things you might that Rob Marchese might have thought of, not the least of which was one of the truthful things, that my wife is having an affair with an adult, which it turns out she was. But this is where prospectively one would think all of these factors that they say should have caused my clients reasonable suspicion, they point you in the direction, I would respectfully submit to you all, in the direction of horses, not zebras. Mr. Popolowski is talking about all of these, and he talks about it in his brief, and despite acknowledging we don't aggregate all of the knowledge of the individual mandated reporters, he keeps saying, no, her wearing a red dress once, when you consider it in light of all the other factors, well, that's aggregating. And he's just said that that's not appropriate to aggregate. And the fact of the matter is no one person did know all of these things. And even some of the factors that they argue in their brief should have alerted us are factors that are not even logical clues to her deviant behavior. The fact that football coaches act like a boys' club or flirt with her or make lewd comments to her, how does that make her more likely to be a child predator? And then the argument continues to be that these factors should have alerted her to the improper conduct, or the others to her improper conduct. One of the arguments is that the fact that she was engaged in an Instagram communication with DOE is a factor that should have alerted us. But we all know nobody knew that. It's like saying, you should have known she was sexually assaulting my client because she was sexually assaulting my client. No, we want to know, what are the things? Let's take her husband. What are the things that her husband knew? I think there's some consensus that he probably saw the most of it. And on the issue of her appearance, for instance, I know I addressed this a lot more elsewhere, but the point has been made that her husband thought her attire was inappropriate, and he even brought it to the attention of another man in the school, actually a social studies teacher. And what's interesting is what came out of that. So what comes out of that is he says to his buddy, and this is all in the record, could you talk to Allison about the way she's dressing? I don't like it. And the buddy says, well, she looks fine to me. What's the problem? And he says, no, talk to her for me. He says, okay, fine, I'll talk to her. So he says to her, Allison, your husband doesn't like the way you're dressing. What gives? And she comes back with something that, interestingly, a number of other witnesses all said they attributed to why it was she wore this back to school night dress. She says to her husband and the buddy, the principal likes the way I dress. And the reason that's important is because we have a new principal who wears a suit and tie, and the previous administrations were all very casual. And so there appears to be some consensus that a lot of people, including this information she's giving her husband, is I'm dressing like this because I'm trying to impress the new administration, who's a lot more formal. So these factors, aggregated or unaggregated, keep pointing us to horses and not zebras. Lastly, I just want to address an argument that the appellant makes in his brief, in which I would respectfully submit he confuses the Haynes versus Middletown standard on imminent harm. He argues that he conflates the magnitude of the injury with the magnitude of the risk. Haynes versus Middletown says it's the magnitude of the risk that compels a municipal actor to act immediately, not the magnitude of the harm. So while I will concede, of course, the sexual assault was a very serious harm, that's not the proper analysis. The proper analysis when analyzing the imminent harm prong of discretionary act immunity exceptions is what is the magnitude of the risk that is presented by the behavior. And I would submit to you that calling a student into your classroom a number of times to go over your yearbook quote, there's not a lot of magnitude of risk that's not a high proposition. It depends on, or I would suggest what was his yearbook quote? Maybe there is a reason to bring him in 12 times. And furthermore, there's no evidence that any one teacher, that he was called out of any one teacher's class more than once. And also, I think it's instructive to remember that even John Doe, too, in this case, when describing his interactions with Allison Marchese throughout the fall, as Mr. Popolowski talks about, he actually describes very few interactions. He himself says, I wouldn't call them flirting. We were laughing. But even the victim here testified, my interactions with her at the school gym, which presumably somebody witnessed, even he says we weren't flirting. Thank you. Those are all my comments.
Are there any questions from the justices? Thank you very much, Mr. Pawlowski.
Thank you. I believe I had cleared up the position of the coaches prior to ending my initial argument that there were two specific coaches who had a conversation, and the other coaches had a conversation about her dress as it related to the students, and the other coaches were talking about it with her and being inappropriate conversations with her. In terms of, I would point your honors to the appendix where we do have copies of Instagram messages between my client and Miss Marchese, and that begins at page 430 of our appendix. And when you go through those, you will see she's identified by name, but then by a number. So throughout that, her number starts with 138, and then there's a 288 number for my client. So that's how they're identified in that. I do believe Mr. Marchese, and I could look through the record again, but he testified about her unwavering attention to those students at the high school game. So it wasn't, and again, it prompted a visceral reaction in part of his book about it. So clearly he noticed that. With respect to him asking a coworker to talk about the dress she was wearing, there is evidence in the record that there was conversation amongst other teachers about that dress. It wasn't just Mr. Marchese, but he's the only one who asked for there to be a discussion about it because it was his wife.
Justice McDonald?
Thank you, Chief. Counsel, so you've acknowledged that we're not supposed to aggregate all of this information and stitch it all together. So in isolation, just clarify for me, from your point of view, who is your strongest witness who could actually testify about seeing individualized conduct that would give rise to the imminence requirement for a mandated report?
Thank you. I think her husband is the strongest, given he witnessed the flirting, and then also had concerns about how she was dressing in the classroom. There's some other information he testified to in terms of her coming to his class and trying to put on a show in front of the students.
But with respect to your client,
yes.
So not other students, but with respect to your client, did Mr. Marchese witness Mrs. Marchese flirting with your client?
No, none of the individuals at the game were my client, but I don't think you lose just because he was at a football game outside of school hours. He didn't lose that knowledge when he entered the classroom.
And I thought I heard opposing counsel say that Mr. Marchese confronted her because of what people were telling him was posted on Yik Yak, I guess it is. I can't even keep all these platforms straight anymore. But so whatever was posted, is that correct? Or did he actually witness flirting?
I'm not sure if he did anything based on the Yik Yak. My recollection of the record is that was between her and the principal, and also reported to the school resource officer, and there was nothing they could do about it. But Mr. Marchese actually witnessed the flirting with students at the football game.
Okay, and you have record citations that we can chase down that record information?
Yeah, his testimony, which I cited before, was about the flirting, and that's in the defendant appendix.
Okay, so what is, I guess I'm trying to figure out in this case what the legal significance of the Instagram posts are. I mean, they took place apparently, that's self-explanatory. Is there any suggestion that any of these mandated reporters saw them?
No, not
So
before.
why are they in this case?
Because it shows that she was flirting with my client, even though it was done via a different communication system.
But, well, okay, let's assume she was flirting with your client. If it was not known to somebody who is a mandated reporter, I'm trying to figure out what the legal significance of it is for this claim.
I agree. It can't be used as a basis of a finding of reasonable cause to report her, since it was not known to any individual from the school system.
Thank you.
As I said before, if there are no questions, I think I've made it pretty clear that I think the mandated reporter statute does not require a significant amount of evidence to make that report. Those reporters are protected by immunity, and I think that's for a good reason. And that report can be based on observations, direct statements, secondhand reports to individuals. And in this case, We think the husband had enough information. I think one of the football coaches had enough information to at least make a report. And the worst thing to happen if they were wrong is that that report would go nowhere. Thank you.
Thank you very much, counsel. With that, we are at the end of today's session of the Supreme Court. I want to thank both counsel for participating in the virtual arguments. It's the way that we decided we can go forward with court in light of the current situation. And I really appreciate your efforts to help us do that. The bar has been extremely helpful. So with that, we are adjourned until tomorrow. I'll see the justices in the virtual conference room.